Hello and welcome. I'm your Professor Glenn Torres-Spelliscy, and this is the International Policy Podcast series. Thanks for joining me. In this week's lecture, we will conclude our discussion of U.S. policies in the fight against international terrorism, with a focus on how the United States treats detainees in its custody. In particular, we will ask whether those detainees should be afforded trials in civilian courts, military tribunals, or whether, as various U.S. administrations have contended, that they can in fact be detained indefinitely. We will ask if it is appropriate and legal to detain people allegedly involved in the conflict without trial, condemning them to a lifetime in legal limbo, where they are neither convicted of a crime nor released to rejoin their families. Now, the war on terror no doubt raises some incredibly difficult yet significant policy issues. As a matter of policy, how we treat people in our custody, particularly when from a moral perspective they may not deserve to be treated gently, how we treat these people is a definitional issue for us as a country. How do we overcome the desire for revenge, the desire to justify anything we do to these individuals under the mantle of national security and self-defense? The lecture and readings this week will range across a number of topics. We'll discuss international and domestic standards related to torture, as well as focus on a series of memos drafted in 2002 by the Bush administration's Office of Legal Counsel, particularly the memos drafted by John Yoo and Jay Bybee. These memos offered guidance to interrogators on what types of practices were allowed and which were prohibited under both domestic and international law. The guidance offered by these memos was in place for about 3 years, and it was wrong. Then in 2004, they were leaked and made public. Shortly afterwards, the Bush administration forcefully and publicly rejected the memo's conclusions. However, as we will discuss in the lecture, although they rejected the memos themselves and some of the memo's broader statements about executive power, they did not reject the enhanced interrogation techniques authorized by the memos that were currently being employed primarily by the CIA at various black sites throughout the world. Indeed, for the remainder of the administration, President Bush took great pains to ensure that new legislation like the Detainee Treatment Act and the Military Commissions Act did not interfere with the CIA's ability to use enhanced interrogation techniques. It wasn't until President Obama signed an executive order that compelled all U.S. government agencies to adhere to the Geneva Conventions concerning treatment of detainees that the enhanced interrogation techniques stopped.
I have put an end to the interrogation techniques described in those OLC memos, and I want to be very clear and very blunt. I've done so for a simple reason, because I believe that our nation is stronger and more secure when we deploy the full measure of both our power and the power of our values, including the rule of law.
There was no public indication that President Trump resumed the techniques, despite statements on the campaign trail that he made. President Biden's position is very similar to that of President Obama's administration. In February 2021, the Biden administration similarly announced plans to study how to effectively close the military prison at Guantanamo Bay. And Defense Secretary Lloyd Austin said during his confirmation that the Biden administration does not intend to bring new detainees to the facility and will seek to close it. In addition to questions of treatment, there's been a lot of discussion about how we legally can dispose of these individuals, whether they should be subject to trials in federal courts or to trials in military commissions. And we even have some of the individuals, as I remarked, who the government says we have to continue to detain, despite the fact that we cannot put them on trial because the evidence against them is tainted. And nowhere in the U.S. Constitution does it say that the government can detain any individual, citizen or not, without charge in a speedy trial. It is possible under international law to detain a prisoner of war until the end of the conflict, but the United States has taken the firm position that these individuals are not POWs under the Geneva Conventions, and indeed it has not treated them in accordance with other POW standards set out by the Geneva Conventions. Now, there are currently only a handful of individuals held in indefinite law of war detention who are not recommended for transfer to another country. Still, we have to figure out how do we deal with them. Do we need to update legal frameworks to permit some sort of indefinite detention, or should they be released? As we approach this week's topic, I want to reiterate what I said at the beginning. This is a definitional issue for our country. It presents fundamental questions that we must ask ourselves, and it's not whether we're good or bad people. That's just too simplistic a classification. I think the key question that we have to pose is this: are we a nation governed at all times and in all circumstances by law, or are we a nation governed by laws that bend to the necessity of a particular political moment? Both approaches have strengths and weaknesses. If we are a nation governed by law, that means first and foremost that no individual is above the law. This is a maxim we always hear, but conversely, it also means that no individual is below the law. All individuals, no matter what their circumstances, are entitled to the same levels of protection. I'm reminded of President Theodore Roosevelt's third State of the Union speech in 1903. Whenever either corporation, labor union, or individual disregards the law or acts in a spirit of arbitrary and tyrannous interference with the rights of others, whether corporations or individuals, then where the federal government has jurisdiction, it will see to it that the misconduct is stopped, paying not the slightest heed to the position or power of the corporation, the union, or the individual, but only to that one vital fact. That is the question of whether or not the conduct of the individual or aggregate of individuals is in accordance with the law of the land. Every man must be guaranteed his liberty and his right to do as he likes with his property or his labor, so long as he does not infringe the rights of others. No man is above the law, and no man is below it, nor do we ask any man's permission when we require him to obey it. Obedience to the law is demanded as a right, not asked as a favor. Now, this approach emphasizes the value of the individual's life and liberty, and represents some of the core values we see reflected in our founding documents like the U.S. Constitution and Bill of Rights. Under this approach, the liberty of the individual is maximized vis-a-vis the safety of the society, and as a result, there is potentially a higher risk that society will suffer harm through some sort of attack, or that a guilty individual will get away. On the other hand, if we believe our laws should be governed by the necessity of a political moment, that they should be somewhat malleable in certain circumstances, that they should bend in order to allow us to achieve certain political goals, we're adopting an approach that emphasizes the importance of the well-being of society as a whole, as compared to the individual. Under this rubric of thought, it is acceptable to mistreat an individual if doing so benefits the society. We are willing to use any means necessary to protect the larger community and likely have a better chance of doing so. But there are a couple of serious reservations I have with this approach. First, there's no guarantee that any individual who is mistreated will provide actionable intelligence. Indeed, most experts who looked at this matter have come to the opposite conclusion, mainly that torture does not provide reliable information. Secondly, and more fundamentally, I think there's a problem of who gets to decide whether and when we're going to derogate from law in a particular circumstance. Who makes that decision? Is it the president? A judge? Should Congress play a role? You see, the problem is that there is a potential for abuse that results from any ability of the government or any individual within the government to deviate from the law when they deem fit. But to be honest, I'm not sure what the right answer is. I know what I think, and I don't want to prejudice you as to what you should think, but what I will say is I've seen arguments on both sides of this debate, put forward by serious thinkers and students of law and policy. From my perspective, I believe that we are a nation founded upon the rule of law, and that all people are equal before the law. That's a founding maxim of this country, and we have to accept the consequences of that reality. If that means that we're not as safe in the short term, I guess I'm willing to accept that, because I believe adhering to that founding principle makes us safer in the long term. Well, that's it for this week's podcast introduction. There's a large amount of material to cover this week, so get to work on reading the lectures and the assigned readings, and let me know if you have any questions, and I will see you on the discussion board.